Hi, in this video we will discuss about patent and intellectual property basics in a very simplified manner. Intellectual property IP or intellectual property rights IPR are of different types, basically of six types. First is patent, which is granted for invention. Next is copyrights, which is granted for expression of idea in the form of literary or artistic work, like when you write a book or when you write an article, it is having a copyright. Similarly, for artistic work, any song or movie which is produced is protected by copyright. Next is trademark and service marks. They basically act as a product or service identifier. Like the company having product will be having trademark. It may register for the trademark for the product of company itself. Company with the service, which are providing only service, they will have service mark. Like LIC, which is providing a service, LIC is having a service mark. Next is design. This is basically to protect the specific product design. So that specific design along with the drawings and all details that will be protected through the design. Next type of IP is topography of integrated circuit. It is basically for electronic circuits which are used in chips, in various machinery, all kind of electronic circuits. They may be protected through topography of integrated circuit. So the circuit design will be protected. Next IP type is GI or geographical indication. It is basically the protection for geography specific properties of product. That geography is responsible for certain properties of the product. Like in case of Darjeeling tea, basmati rice. So Darjeeling tea, which is coming from Darjeeling hilly area, is having special characteristic, special taste because of that hilly area environment. So that Darjeeling tea is protected by geographical indication or GI. Now let us discuss what is patent. Patent is an oldest form of intellectual property. It is a type of IP or intellectual property. It is an oldest form of IP protection introduced to encourage economic and technological development by rewarding intellectual creativity. Patent is a grant of exclusive right to inventor by government of a country to exclude others from making, using, selling or importing of that invention for a set period of time, which is usually 20 years from date of filing. Patent is also an integrated legal and technical document. If you see the patent document, it is having a huge amount of information. It is called legal because the claims which are written in the patent document, they set the legal boundary of protection for your invention. So whatever you want to claim, you should write down in the claim section. Whatever is not written in the claim will not be protected. So whatever you want to claim, you should write in the claims. So claim sets the legal boundary of protection. So that's why it's a legal document. The specification part or description part of patent is technical information part. It provides all technical information related to that invention. So this is technical part. That's why it is called technical document. So description part provide all detailed information, complete detailed information about your invention, including the best way and manner of practicing the invention, along with examples. So patent document is basically a legal as well as technical document. It is very informative, having huge amount of information about the invention. Now coming to objectives of patent grant. The objective of patent grant are to promote innovation and economic and technological development by providing incentives or rewards for inventing in the form of exclusive rights to patentee or inventor to make, use, sell or import the invention for a limited period, which is 20 years from filing date. So government grants exclusive right to inventor in exchange of complete disclosure of invention to public. So in exchange of getting exclusive right, the patentee or inventor now has to disclose his invention in complete detail so that others, the public, can learn from that disclosure, and the public can develop or others can develop the alternatives to that invention so that they can compete with the inventor during patent term or before expiry of the patent. So during patent existing term or before expiry of patent, the other companies or other people, they may develop alternative products related to that invention, and they can compete with the inventor during patent term before expiry. And also others can practice the disclosed invention after expiry of patent term. Once the patent has expired, anyone can practice or use that invention. Now requirements for patent grant. So what are the requirements for patenting an invention or patentability requirements? We'll talk in this slide basically for US. So first requirement is utility requirement. Invention should have at least one utility or one industrial application or use. If it is not having any use, then patent will not be granted. Second requirement for patentability is novelty. Invention should be new or novel, and it should not be anticipated by prior art or prior knowledge. Prior art is basically any relevant prior published literature or knowledge, even if it is not published. The traditional knowledge is also covered by prior art. So any relevant prior published literature or any prior knowledge about invention before filing date of your application is called prior art. So your invention should be new and it should not be anticipated by prior art, or it should not be anticipated by any prior publication or knowledge. Third requirement is non-obviousness or inventiveness. Invention should not be obvious to one of ordinary skill in the art, and it should involve at least one inventive step. The ordinary skill in the art is the person who is skilled in that field. Like in case of chemical invention, the person of ordinary skill in the art will be a graduate in chemistry or in chemistry field. So invention should not be obvious to one of ordinary skill in the art. Let us understand with an example. Suppose two drugs are used together. A doctor is prescribing drug A and B together. Now somebody comes with a combination of those two drugs in one formulation or in one tablet and files for patent application. He will not get the patent because it is obvious to combine these two drugs in one formulation because both are being used together. So that will become obvious. So your invention should be non-obvious and it should involve at least one inventive step. Fourth requirement of patentability is disclosure in specification. There should be complete disclosure of your invention with examples. Otherwise, you will not get the patent. So, under disclosure requirement, disclosure in specification requirement, there are four further requirements. First is written description. There should be complete disclosure of invention in patent application with example. You cannot hide anything. You have to disclose everything about your invention in written description. Next is enablement. The invention should be well explained so as to enable person of ordinary skill to practice the invention without undue experimentation. Your invention should be explained in such a way with example that one ordinary person can practice that invention without any undue experimentation. Next requirement is best mode disclosure requirement under written description. The best mode or method of practicing your invention, the best mode which is known at the time of invention, should be disclosed. You cannot hide the best mode. If you hide the best mode, it can become ground for challenging your patent. So you have to disclose the best mode of practicing the invention. Next requirement under disclosure in specification is claim definiteness. The language of claim should be precise, definite, and non-ambiguous. The language should not be ambiguous. It should be clear and precise. If the language is not clear and precise and it is not definite, then it can become ground for challenging the patent. So these are the basic requirements for getting a patent: utility, novelty, non-obviousness or inventiveness, disclosure requirement in specification in form of written description, enablement, best mode, claim definiteness requirements. So these requirements are important. You need to fulfill all these requirements in order to get the patent. And these requirements are also ground for challenging a patent. Once the patent has granted, it can be challenged. You can challenge a patent validity on any of these grounds. You can challenge on utility ground if you find that there is no industrial utility for that invention. On novelty ground, if you find any prior publication about that invention, you can show to the patent office or court in your opposition or in invalidation proceeding that this article is published about this invention before filing date. So on novelty ground also you can challenge a patent. Non-obviousness and inventiveness ground also you can challenge a patent. You can say that the invention, you can find out some article or some information that this information is obvious to patent. So the invention is obvious. Anybody can try this invention in light of these published article or literature. You can also claim a patent on basis of description ground. If you find that written description is not complete, not given with the examples, it is not enabling a person of ordinary skill to practice the invention. If the best mode is not disclosed, or if the claim are not precise and clear, you can claim on, you can challenge the patent on that ground also. Now, different components of a patent document. If you see the first page of a patent document, you will find the bibliographic information or bibliographic details. like inventor name, applicant name, application number, patent number, priority date, filing date, grant date, etc. Then title, abstract. Basically, title and abstract are also part of bibliographic details. The next part of patent document is specification or description, which is the longest part. In specification, you have to describe the field of invention. Your invention related to which field? You have to describe that field. Then next section is background or prior art related to that field or related to your invention. So what is the prior literature or knowledge which is published before your filing date about that invention? Then you have to describe the disadvantage of the prior art or prior information. Then you have to summarize your invention, what your invention is providing, what benefit your invention is providing over prior art or prior knowledge. And then you have to describe the invention in detail, in detailed description along with example. Complete detailed description of invention, complete disclosure with best mode, enablement, claim definiteness, etc. The next section is drawing. If any drawing, you have to describe all the drawings in detail in drawing section. And the last section and most important section of the patent document is claims. Claims are most important component of a patent, defining legal boundary. Claims define the legal boundary of your protection. Whatever is written in the claim is protected. Whatever is not written in the claim is not protected. So be careful. Whatever you want to protect, you need to write it down in the claim section. So claims are most important part of patent document, and claims set the legal boundary of protection for your invention. So here you will see the US patent document. So this is the first page of US patent document with bibliographic information. You will see the patent number, grant date, the title, the inventor, the assignee, company name, the application number, the application filing date, the provisional application number, the provisional filing date, and the abstract. The last section of the patent document, you will see in the last of the patent document the claim section. If you see the green highlighted circled portion, this is the claim portion. So it says what is claimed is, then he claims in 8 different claims whatever he wants to claim. So whatever is to be protected, you should write in the claims. So claim section is most important part of patent document. The last slide is on types of patents in US. Basically 3 types: utility patents, design patent, and plant patents. Utility patent, basically all pharma patents are covered in utility patents. Utility patent may be granted to anyone who invents or discovers any new or useful process, maybe a new machine, maybe new article of manufacture, maybe composition of matter, or any new useful improvement thereof. So term of utility patent will be 20 years from filing date if the filing date is after June 8, 1995. By far most of patent application filed at USPTO or US Patent Trademark Office are utility patent application. So utility patents are the important ones. Most of the patents filed are utility patents. All pharma patents are basically covered under utility patents. So pharma patent under utility patent, you can claim either as a process patent or formulation patent, composition patent, product patent, which is usually called composition of matter patent. Next is design patent. Design patent basically protects the ornamental appearance of an article, such as its shape or configuration or its surface ornamentation. So basically, it protects the design or shape, not the functionality of that design, only the design or ornamental design of that article. So anyone may be granted design patent who invents a new, original, and ornamental design for an article of manufacture. US design patent resulting from application filed on or after May 13, 2015 have a 15-year patent term from date of grant. Earlier, before May 13, 2015, the term of patent was 14 years from date of grant. Last is plant patent. Plant patent may be granted to anyone who invents or discovers and asexually reproduces any distinct and new variety of plant. A plant patent expires after 20 years from filing this. So the term of plant patent is 20 years. So that's all in this video. Thank you very much.